Both of those, whoever the representative payee has to provide accountings back to Social Security. I usually advise clients, let the representative payee handle that and not seek conservatorship. Mainly because when I hear people complaining about guardianship and all the paperwork that's involved, what they're really complaining about is conservatorship. The paperwork involved in a guardianship, once it's been established, it's a 2-page personal status report due once a year. And it's a pretty straightforward, where's the individual living, how are they doing, any changes that we need to make to the guardianship, sign, date it, and file it. Whereas on the conservatorship side, you have the asset management plan, which is, this is what we're going to do with his money. And then there's the accounting, this is what we did with his money from last year. And that, that whole thing has to kind of be presented to the court. And if your math doesn't add up, like mine didn't on one, you'll get a nice little notice from the judge saying, get down here and explain this to me. And that, is extra time, and whenever a lawyer has to spend time, it translates to money for the client. So, but just so you know, the judges in the state don't always agree on how this is to be handled.
We do things very differently. And I will tell you that in our court, if somebody is receiving only Social Security benefits, and we do a conservatorship, and the conservator is the representative payee, we do not require a bond. And we allow an abbreviated report on what was done with the assets. So it's not, we don't require each entry. We just say, if you put Social Security benefits as rep payee used for the health maintenance and benefit of the ward, that's generally sufficient to sort of simplify it. There aren't a lot of people who do it that way. So I will tell you, I think what most of the courts, when you've got Social Security benefits, they will require a bond, which we'll get into, which is an insurance policy that you're not going to steal the money on a year's worth of income, because that's what the code section says. But if you're the representative payee, you're accountable to Social Security. If you mismanage it, they will typically replace it and make the recipient whole. So we don't want to take away money from a Social Security benefit recipient by making them post a bond out of those proceeds. So that's how we handle it.
Child has a special needs trust.
That's not within my jurisdiction. I don't manage that. I don't have anything to do with that.
Remember last time? I said the court is out of it. The court doesn't have anything to do with it.
And we don't want to know about it. Unless it's money that's being then paid to the conservator for day-to-day management, then that check is income that you report, because
I'm talking about something just laying there.
No, but what I'm saying is, if it's in a trust,
it's not in her jurisdiction.
I don't know about it. It doesn't occur. It doesn't happen.
You don't have to put it on paper.
Right, because it's not. But if you write a check and then that's used to buy clothes and all of that kind of stuff, then it's income and outgo, and you have to report it, and you're entitled to a commission on it, and you're going to be bonded on it.
But that's only if there's a conservatorship.
Right.
The trust can pay that money to the guardian, and the guardian can use it for the benefit. That's a trust issue. The trustee is legally responsible to see that that money is used for the beneficiary's benefit. So if the trustee screws that up, the beneficiary or the beneficiary's representative can actually take the trustee to court, but not in her court, in superior court. Whole different rules.